Hi, I'm Lauren. I'm a solicitor at Legal Aid New South Wales. I work in a specialist unit called the Older Persons Legal and Education Unit. The best way to go about having a will done is to have a professional, such as a solicitor or the New South Wales Trustee and Guardian, or a private trustee company do your will for you. It's really important that your wishes are expressed clearly, so that reduces the chance of your will being challenged after you die. And also there are taxation issues, pension issues and other issues that you might want to consider. So having a professional do it for you means that you can be sure that it's done properly. And having a professional do your will doesn't need to be very expensive. There are some legal requirements for making a valid will. Firstly, the will has to be in writing. Secondly, the person making the will maker, must sign the will at the end of the document. And also the will maker's signature needs to be witnessed by two people who are present at the time the will maker signs the will. And also a beneficiary under the will shouldn't be one of those witnesses to the signature. Some of the things that need to be considered when you're making a will are, firstly, does the person making the will have capacity? So that means, does the person understand what a will is and what they're doing by making a will? If you're making a will, you also need to think about what is it that you own and what would you like to happen to that property when you die. You also need to think about who you'd like to be your beneficiaries under the will. And that could include a charity as well as the people in your life, family and friends. You also need to think about who you'd like to appoint as your executor. The executor is the person whose job it is to manage your affairs and distribute your estate in accordance with your will when you die. And it's important to talk to that person too, because it is a fairly responsible job, and so it's a good idea to let them know that you're thinking of appointing them as an executor and make sure they understand what is involved. It is possible to put your wishes for your funeral into the will, but if you do that, then of course it's important to tell your executor what your wishes are, because very often the will is not looked at until well after the funeral. You can change your will at any time and as often as you like, as long as you have the mental capacity to do so. So that means that you understand that you're changing your will and what a will is. So for example, if someone has developed advanced dementia or has suffered a brain injury since they made their will, they'll no longer have capacity to do that. If you are thinking about changing your will, it's actually a good idea to do a completely new will. And it's not okay to cross out something in your will and write something new on it. Also, if you marry or divorce, or if your circumstances change in other ways, it's a good idea to talk to a solicitor about whether you should make a new will. You can get more information about wills or how to go about making a will by calling Law Access New South Wales. Law Access is a free government telephone helpline, and they can give you information and they can refer you to a private solicitor or the New South Wales Trustee and Guardian.